Turner, the immigration barrister at Imperium Chambers, bringing you the news in the world of immigration as it happens, or as I come to hear of it. Today I'm going to talk to you about a pilot scheme in relation to remitted appeals. I've not heard of this scheme before and first found out about it today after arriving at Harmondsworth Immigration Court. The hearing was listed as a case management hearing following a successful appeal to the upper tribunal, where they set aside the first decision on the basis that it was fundamentally flawed. Normally, when cases are remitted, they're usually set down for another hearing. So a case management review hearing in itself was a little unusual, surprising, but not unheard of. Having arrived at Harmondsworth, I was then informed that the CMR was to be held in chambers. What this means is that the hearing takes place in a room with the judge, the representatives, but not the public. This is the first time that this has ever happened to me, or that I was aware of it happening. Present was the ever-present judge, a member of the tribunal staff, and Home Office presenting officer. It was in fact a small office rather than a court, and certainly not big or daunting. The judge helpfully explained the nature of the pilot, and I think it merits a broadcast given the potential cost implications and importance in making sure that your case is properly prepared for when it comes for its remitted appeal. Apparently, a number of cases that have been remitted back from the upper tribunal to the first tier tribunal arrived with the papers in a bit of a mess, making it harder for the appeal to proceed. There would be old bundles, new bundles, supplementary bundles, skeleton arguments, grounds of appeal. The consequences were that some hearings were either not effective or had to be adjourned, wasting tribunal time. The purpose of the informal CMR was to check whether the parties were in a position to proceed for the full remitted hearing and whether any other directions were needed. So far, nothing unusual. It's what usually happens to the CMR. However, the court's directions are of some importance. In order that the next hearing be effective, the tribunal are keen that the cases are properly prepared. In order to effect this, the court issued the following directions, and they are very important. That within a set period of time from the CMR, a new consolidated bundle of documents be prepared. Not merely the old bundle and a new supplementary bundle. The court were absolutely clear that they wanted all the evidence in one consolidated bundle. And unusually, they wanted that bundle served within a set period of time from the CMR, as opposed to it being served a week or so before the hearing. Again, nothing particularly controversial. However, the second part of the order is important. The court directed that if the above directions were breached or a further application for an adjournment was sought, either party would have to show why they should not pay wasted costs. In my view, this marks a significant shift away from the previous regime, whereby in remitted hearings, often all that would be prepared would be a short supplementary bundle filed a few days before the hearing with a skeleton argument. Whilst these directions may seem a little harsh, the court were clear to emphasise that they applied to both parties, to the Home Office as well as to applicants and appellants. This means that appellants will need to work closely with their representatives to get their cases together. And secondly, it could provide, by way of cost penalties, against the Secretary of State turning up and producing evidence on the last day, even if the documentation relates to an application for entry clearance in 1804 by someone's great uncle's aunt, and has no relevance to the case other than to mean that the case can't proceed. I jest as to the last point, but I would not be the first barrister to be bounced by documents being handed up at the hearing, which has led to an adjournment with the necessary wasted costs and further delay for my client to get his matter resolved. At this stage, it's only a pilot scheme being run at Harmondsworth, and in my view it's an excellent opportunity to put forward any new issues or clarify any matters with the Home Office. In my case, it gave me the opportunity to explain how strong the case was and to ask to have it reconsidered, because in my, as I say, I think my case is pretty much very winnable. As I say, it's a pilot. I'm not sure whether it will be rolled out or whether it will not be rolled out. I will, of course, update through this channel any further information on this pilot that I hear. What it does mean, as I say, and I reflect back on it, what it does mean is that you will need to work closely with your representatives in order that they can comply with the directions. As I say, this is a case where costs are being mentioned in the directions, and these are costs that you could end up bearing, and this is something that has to be avoided at all possible costs, if you'll pardon the very bad pun. Should you have any questions or immigration problems, particularly in respect of this issue or any other issue, please do not hesitate to contact me, Paul Turner, the immigration barrister at Imperium Chambers, on 0207 242 3488, clerks@imperiumchambers.co.uk, or at my own site, theimmigration.barrister.co.uk. This has been Paul Turner, the immigration barrister. Thank you for watching.